Okay, welcome to Constitutional Law 2, a very different beast than Con Law 1. But keep in mind, as I said in the intro, that they're flip sides of the same kind of story. In Con Law 1, we studied the structure of government, some of the limits on each government, right? The scope of power of the federal, judicial, legislative, and executive branches, and the scope of police power, and limits on some of each one of those. One of the primary limits on the power of government is individual rights. And so we'll talk more about that in a live session. But of course, as the first video that's going up, have to put that, at the beginning. Rights are not a grant of license from the Constitution to people, right? License to do certain things, certain discrete acts. They are rather a reservation of power, right, to the people, and therefore a limit on the power of government. And here we're talking about a limit not only on the power of the federal government, but also on the power of any state or local government, subdivision of the state. We have to start off, unfortunately, with a very technical issue. When you talk about individual rights, of course, what pops to mind for a lot of Americans would be the Bill of Rights. The Bill of Rights is the first 10 amendments to the Constitution. The Bill of Rights was added to the Constitution by the first Congress, and then, of course, Congress proposed the first 10 amendments. They were ratified by the states. The addition of the Bill of Rights to the Constitution was basically a political compromise designed to get reticent states, right, to agree to sign on to a constitution. The perceived problem was that if we were going to create a new central government, a new national government, right, which did not exist before the Constitution, that it would be a dangerous and powerful beast and would have to be restrained somehow. Now, it was very controversial during our founding, right, whether we should have a Bill of Rights in the Constitution, because the founders knew that if they started listing rights that they were going to forget some, right? Or that the Bill of Rights might be perceived as an exhaustive list. And we'll talk more throughout the term about John Locke, right? The whole idea here is not to list specific, discrete, individual, like I said, acts that people are allowed to do, but to reserve the general power over a person's own affairs, right? Their own property, their own liberty, their own life, to the extent they're not bothering anybody else, to reserve that to the people. So creating a list is very dangerous. You know that because you know the expressio unius rule, right? Which is if you start listing things, right, you're going to be stuck to the list. Thus we have the Ninth Amendment, more on that later, right? But you do want to take a close look at the Ninth Amendment. Okay. Now the first thing about the Bill of Rights. The Bill of Rights, as I just said, was intended to restrain the national government. So you'll notice how the First Amendment starts. The First Amendment starts with the words, "Congress shall make no law." Now, from our study of Con Law 1, you know that these words matter, right? And Congress, of course, is the federal government. And you see your favorite mascot is still with us, Lainey repositioning herself. Okay, because she knows she's about to get hit with the doctrine of selective incorporation. Serious stuff. All right. So here's the question. If the First Amendment applies to the federal government, and I should add that the First Amendment, the way the First Amendment starts, that Congress shall make no law, that's considered to lead into all of the Bill of Rights. So the Bill of Rights seems to apply, at least the first 8 amendments. Again, just take all this with a grain of salt. I'm generalizing here, but the first 8 amendments apply to the federal government. So what happens when the state of Florida passes a law, right, abridging your freedom of religion, or establishing religion, or abridging your freedom of speech, right, just to stick with the First Amendment? Florida would then claim, right, that when you look at the text of the Constitution, and particularly the Bill of Rights, that the Bill of Rights does not apply to the state of Florida because Florida is a state, right, and the Bill of Rights applies to the federal government. It is true that the Bill of Rights appears to target not the state level of government, but the federal level of government. But we have a history, right? The first 10 amendments are not the only amendments. The fear at our founding was that the federal government would be the source of mischief, right, and frankly, evils, right, and overreach. It turned out after the Civil War that we discovered that states are equally, if not in some circumstances more likely, to cause trouble, right? Especially when states reflect tribalism and hostility. Thus was born the post-Civil War amendments, right? The 13th, 14th, and 15th amendments. The 14th Amendment is one that we are going to be spending a whole lot of time talking about. And the 14th Amendment clearly targets states. The first sentence of the 14th Amendment overrules Dred Scott. More on that. We might have talked about that a little bit in Conlo 1, but we'll talk more about it. The second sentence of the 14th Amendment is where the rules really start. And look at the way that is, right, if you've got your book in front of you or your pocket constitution, take a look at the 14th Amendment and look at the way the second sentence starts, right? It says, no state shall. So we have the first 10 amendments that clearly target the federal government, but the 14th Amendment, post-Civil War, when the states were the ones causing all the trouble, post-Civil War, right, we have a 14th Amendment that obviously and clearly targets states. The 14th Amendment has three primary clauses in it. It has a due process clause, which we're going to start with. The due process clause says a state cannot take away your life, liberty, or property without due process. By the way, the Fifth Amendment says the same thing, right? That the government cannot take away your life, liberty, or property without due process. But the Fifth Amendment applies to the federal government, right? The 14th Amendment applies to states. There's also an equal protection clause in the 14th Amendment. No state may deny to any person within its jurisdiction the equal protection of the laws, and that's the first time the equality principle shows up in the Constitution. We'll be talking about the equal protection clause for weeks. Finally, there's a privileges and immunities clause in there, right? The state's not allowed to deny privileges and immunities of citizenship. More on that in a little bit. Okay. Could it be after the adoption of the 14th Amendment, right, which when you look at the broad principles incorporated right into the 14th Amendment, fairness, right? Due process is about fundamental fairness and the way the government deals with the people, right? And the way the government deals with the people who are under the jurisdiction of the government. That's what due process is all about, fairness. Equality is about fundamental fairness, right? The state behaving itself, right? And not targeting people for arbitrary reasons. So could it be after the adoption of an amendment, right, that has these principles embedded in it of fundamental fairness in the dealings between the government, the state government, and the people, that states like Florida or any state are still allowed to violate people's enumerated rights as listed in the Bill of Rights? In other words, does the 14th Amendment know this word, incorporate, right? Does the 14th Amendment incorporate the Bill of Rights as against the states? So we'll talk more about this during, live session review, but here's what courts have said. The due process clause, so you have to know the specifics of this. The due process clause in the 14th Amendment uses the word liberty, right? And courts have very broadly construed what that means. And what courts have said is that as a matter of due process, right, which states are required to provide, and as a matter of honoring liberty, right, which the 14th Amendment seems to require of states, the most of the rights in the Bill of Rights are incorporated against the states. That's fancy language for meaning that the states have to follow these rules, right? So I'm going to go through them very quickly. What the court has basically said, it would have been easy if they just said it's all incorporated or none of it's incorporated, right? All of the first 10 amendments or none of the first 10 amendments. Let's get this on the table right now. The 9th and 10th Amendments don't actually list rights, so we're going to talk about 1 through 8. We'll talk about 9th and 10th in a different context, but when you look at the Bill of Rights 1 through 10, it's only 1 through 8 that actually list rights. The 9th and 10th have different functions. So which of the first 8 apply to the states? Well, some of them are not that important, or in one case, downright silly. Courts have not said that all of the Bill of Rights apply to states. They've said that most of them do. So here we go. The important ones do, right? Is the First Amendment important? Of course it is. So the First Amendment applies to the states. Is the Second Amendment important? Yes, it is. And we've discovered, actually, just within the last decade or so, that the Second Amendment also applies to the states, right? So First Amendment, freedom of speech, religion, all that applies to the states. Second Amendment, right to bear arms, applies to the states. So states can't violate that right any more than the federal government can. The Third Amendment is the first one we run into that really has not been litigated. That's the one about soldiers quartering in people's homes. That has simply not been a problem throughout our history. So it's never been litigated up to the Supreme Court. So the Supreme Court has never said that the Third Amendment applies to the states, so it doesn't, okay? So the First applies against the states, right? The First has been incorporated, the Second has been incorporated, the Third Amendment has not been incorporated. The Fourth Amendment, all that good crim pro stuff about search and seizure and all that, has been incorporated against the states. The Fifth Amendment, pretty familiar to most Americans, plead the Fifth, right? But there's a due process clause in there. There's the right to the right not to be a witness against yourself and all that good stuff. All of that's incorporated against the states with one exception, and that's the grand jury requirement. In the federal system, you cannot be indicted for a crime unless you're indicted by a grand jury. The question is whether the Supreme Court was going to make states follow that rule. And as I'll discuss with you during our live session, a grand jury, the grand jury protection, is not very protective. It turns out that the grand jury system is pretty useless for reasons we'll discuss. So it's not much of a protection, and judges know that. So the Supreme Court said we're not going to require every state to have a grand jury system. That's a whole lot of logistical nightmare for very little constitutional protection. The Sixth Amendment, right to counsel. I hope you know the case Gideon, right? The Gideon case from Crim Pro. Where the issue was whether states have to provide counsel for indigent defendants, and the Sixth Amendment, the court held, does apply to the state, so the Sixth does. The Seventh is a silly provision written into the Constitution that you're entitled to a jury trial anytime the amount in controversy is over $20. Apparently the founders were not familiar with the concept of inflation, right? $20 is not what it used to be. There's no way the Supreme Court's going to require states to provide jury trials, right, when the amount of controversy exceeds $20. So the Seventh Amendment does not apply to the states. The Eighth Amendment used to be a kind of a split, but good for law students. This because it makes it a little easier. In a recent case, the Supreme Court made it very clear that the entire Eighth Amendment applies against the states. It used to be the rule that the cruel and unusual punishment part of the Eighth applied against the states, but the excessive fines part didn't. But you don't have to worry about that anymore. At this point, the court has said that the entire Eighth Amendment applies against the states. Now, as I mentioned, the Ninth and Tenth Amendments have different functions, and we'll talk about those in a separate video. It's easier when it comes to the doctrine of selective incorporation, and you need to know this doctrine. The doctrine of selective incorporation, which parts of the Bill of Rights apply to the states and which don't. Right, it's easier to remember which parts of the Bill of Rights don't, because there's fewer of those, right? So basically the entire Bill of Rights, 1 through 8, applies to the states, except what? Except for the Third Amendment, the Fifth Amendment grand jury requirement, and the Seventh Amendment, right? All of the rest of it applies to the states. The doctrine of selective incorporation runs through the due process clause of the 14th Amendment. Failure to plead that accurately can lead to big legal trouble. If you have a First Amendment case, right, against the state of Florida, you have to know how to plead that case, right? You would plead a First Amendment violation against the state of Florida, right, or a government official from the state of Florida, right? You would have to plead it through the 14th Amendment. You would say, the state of Florida has violated my client's right to free speech, right, First Amendment right to free speech, as it applies to the state of Florida through the due process clause of the 14th Amendment. Why? Because the 14th Amendment is the one that applies to states, and the due process clause of the 14th Amendment is the part of the Constitution that gets the Bill of Rights, most of the Bill of Rights, to apply against the states as a matter of fundamental fairness. Okay, that's a good overview of selective, I hope it is anyway, a good overview of selective incorporation. Be back with more videos coming up here, but we got that matter out of the way. So we'll get on to the good stuff and the more fun stuff here in a little bit.